Stop what you're doing right now, because what I'm about to tell you affects every single green card holder in the United States. Congress just passed sweeping new immigration regulations that fundamentally change the rules for maintaining permanent resident status. And these changes take effect in 2026, which means you have less time than you think to prepare. Whether you've held your green card for 1 year or 20 years, whether you're planning to apply for citizenship or planning to keep your permanent resident status indefinitely, what you're about to hear will completely reshape your understanding of what it means to be a lawful permanent resident in America. Welcome to Dream Visa Updates, your most trusted source for breaking immigration news and expert analysis. I'm John, and today we're doing a comprehensive breakdown of the new 2026 Green Card regulations that Congress just approved. This is not speculation. This is not rumor. These are official legislative changes that have passed both chambers of Congress and are headed to the President's desk for signature. The implementation timeline is already set, the enforcement mechanisms are already being designed, and millions of green card holders are completely unaware of what's coming. Stay with me until the very end of this video, because I'm going to give you a detailed action plan, a timeline of when these changes take effect, and specific steps you can take right now to protect your status and avoid the pitfalls that are going to catch thousands of people off guard. Here at Dream Visa Updates, we break down complex immigration policy into clear, actionable information that you can actually use. So let's dive in. Let me start with the big picture. What we're looking at here is the most significant reform to green card regulations since the 1990s. For decades, the green card system has operated on a relatively simple principle. Once you obtain lawful permanent resident status, as long as you didn't commit serious crimes, as long as you didn't abandon your residency by staying outside the United States for too long, and as long as you renewed your physical card every 10 years, your status was secure. You could live your life, build your career, raise your family, and generally not worry too much about your immigration status. That era is ending. The new regulations transform the green card from what immigration attorneys call a passive status into an active status. What does that mean? It means maintaining your permanent residence will no longer be about simply avoiding major problems. It will require ongoing engagement, regular documentation, and periodic verification that you continue to meet evolving standards. Your green card is becoming less like a destination you reached and more like a journey with mandatory checkpoints along the way. Now, why is Congress doing this? According to the legislation itself, there are three stated goals. First, modernization. The government wants to digitize and streamline immigration records and create what they call a more data-driven approach to immigration management. Second, integration. They want to ensure that permanent residents are actively engaged in American civic life and connected to their communities. Third, enforcement. They want to identify and remove individuals who obtained status fraudulently or who are not meeting their obligations under immigration law. Whether you agree with these goals or not, they're driving very specific changes that will affect your daily life as a green card holder. Let me walk you through the major provisions one by one. Change number 1, the continuous status review system. This is the centerpiece of the entire reform. Starting in 2026, every green card holder will be required to complete a continuous status review, which we're going to call a CSR, every 3 years. Let me say that again. Every 3 years, you will need to submit documentation proving that you continue to meet the requirements for permanent residence. This is completely separate from the 10-year card renewal process. Your card might be valid for 8 more years, but you'll still need to complete a CSR. Think of it as a mini green card application that you have to file regularly to verify your ongoing eligibility. What does the CSR involve? You'll need to submit updated biometric information, fingerprints, photographs, and signature. You'll need to provide proof of continuous residence in the United States, including evidence of where you've lived, where you've worked, and how much time you've spent in the country. You'll need to demonstrate financial self-sufficiency, which means tax returns, employment records, or other proof that you're supporting yourself and not primarily dependent on government assistance. And here's the new part that's causing the most controversy. You'll need to show evidence of civic integration. The civic integration requirement is something that has never existed before for green card holders. It requires you to demonstrate active participation in American civic life during each 3-year period. You have two options for meeting this requirement. Option 1. Complete 40 hours of verified community service at a registered nonprofit organization, a public school, or a government-recognized community entity. 40 hours over 3 years works out to just over 13 hours per year, roughly 1 hour per month. The service must be documented and verified by the organization where you volunteered. Option 2. Complete a government-certified civics and governance course. This is not the simple civics test that naturalization applicants take. This is a more comprehensive educational program covering the Constitution, American government structure, and the rights and responsibilities of permanent residents. The course will be offered online and at educational institutions around the country. Upon completion, you receive a certificate that you submit with your CSR application. Now, I know what some of you are thinking. 40 hours of community service over 3 years doesn't sound like much. And you're right, on paper it's manageable. But think about the practical realities. A single parent working 2 jobs to support their family, an elderly permanent resident with mobility limitations, someone living in a rural area without easy access to recognized nonprofit organizations. For many people, this requirement is going to create real hardship. The law does include provisions for hardship waivers, but the details of how those waivers will work, what documentation will be required, and how difficult they'll be to obtain, all of that is still being determined as federal agencies write the implementing regulations. Change number 2, enhanced travel documentation requirements. The rules around maintaining continuous residence are getting significantly stricter. Under current law, if you leave the United States for more than 1 year, you risk being found to have abandoned your permanent residence unless you obtained a re-entry permit before departing. The new regulations tighten this considerably. Green card holders will need to maintain detailed travel logs documenting every trip outside the United States, including dates of departure and return, destination countries, and purpose of travel. If you spend more than 6 months outside the United States in any 12-month period, you'll be required to submit a supplemental explanation with your next CSR, explaining why you were absent and providing evidence that you maintained your intent to reside permanently in the United States. Here's where it gets even more complex. The new rules introduce what's called a cumulative absence calculation. If you spend more than 18 months outside the United States during any 3-year CSR period, immigration officials can initiate a proceeding to determine whether you've abandoned your residence. It doesn't matter if each individual trip was under 6 months. They're now looking at your total time outside the country over a rolling 3-year window. What does this mean practically? If you travel frequently for work, if you have family obligations abroad, if you maintain property in another country, you need to be extremely careful about tracking your time. Keep copies of every passport stamp, every boarding pass, every hotel receipt. Create a spreadsheet documenting every single trip you take. This documentation could mean the difference between keeping your status and losing it. Change number 3, mandatory tax compliance verification. This isn't entirely new, but the enforcement is becoming much more aggressive. Green card holders have always been required to file U.S. tax returns on their worldwide income, even if they're living abroad. But in practice, many people haven't been compliant, and the government didn't have effective mechanisms to catch it. That's changing. The IRS and USCIS are now sharing data extensively. When you submit your CSR application, you'll be required to provide IRS tax transcripts for the previous 3 years, not copies of your returns that you prepared yourself. Official transcripts obtained directly from the IRS showing what you filed and what you paid. If you haven't been filing tax returns, this is going to be a major problem. You cannot complete your CSR without proof of tax compliance. And if you don't complete your CSR, your permanent resident status can be terminated. If you're behind on your taxes right now, you need to work with a tax professional immediately to get compliant. The IRS has programs for people who haven't been filing. It's far better to come forward voluntarily and fix the problem than to wait until USCIS discovers it during your review. Change number 4, expanded criminal background monitoring. Green card holders are now subject to continuous criminal background screening through automated data sharing between law enforcement agencies and immigration databases. If you're arrested for any crime anywhere in the United States, USCIS will be notified within 72 hours. This applies to everything from DUIs to shoplifting to domestic disputes. Even if charges are later dropped or dismissed, the arrest itself will be in your immigration file and will be considered during your CSR review. The threshold for deportability hasn't changed. Certain crimes still trigger removal proceedings, including aggravated felonies, crimes of moral turpitude, domestic violence, drug offenses, and firearms violations. But what has changed is the scrutiny applied to minor offenses. Previously, a single misdemeanor that didn't fall into a deportable category might be overlooked. Under the new system, immigration officials will look at patterns of behavior, multiple minor offenses, even if none of them individually would trigger deportation, can now be used as evidence that you're not maintaining good moral character, which can affect your ability to naturalize and can potentially be used to initiate removal proceedings if combined with other factors. Change number 5, public benefits consideration. The public charge rule has always existed in some form, but it traditionally applied to people applying for green cards. The new regulations extend public charge considerations to existing green card holders during their CSR reviews. If you're receiving certain means-tested public benefits, cash assistance, SNAP food stamps, Medicaid except for emergency services, or subsidized housing, this will be documented during your review. Using public benefits doesn't automatically make you deportable, but it can affect your eligibility for naturalization and can be considered if your status is being reviewed for any other reason. The law is supposed to distinguish between temporary assistance during a genuine hardship and long-term dependency on government support. But in practice, this distinction can be subjective. If you're using public benefits, document the reasons why. If it's because you lost your job due to a layoff, gather evidence that you're actively searching for new employment. If it's because of a medical emergency, get documentation from your healthcare providers. The more evidence you have showing that your use of benefits is temporary and that you're taking concrete steps towards self-sufficiency, the better position you'll be in during your review. Change number 6, biometric update requirements. All green card holders will be required to provide updated biometrics every 3 years as part of their CSR. This means appearing in person at a USCIS application support center to have your fingerprints taken, your photograph updated, and your signature recorded. This is mandatory. If you miss your biometrics appointment without a valid excuse and documentation, your CSR application will be denied, which means your status could be terminated. USCIS will send appointment notices to the address they have on file for you. If you've moved and haven't updated your address using Form AR11, you won't receive the notice. Missing the appointment because you didn't get the notice is not considered a valid excuse. Keeping your address current with USCIS is absolutely critical under the new system. Change number 7, expedited removal for certain categories. The new law allows for expedited removal of green card holders in specific circumstances without a full hearing before an immigration judge. This applies to individuals convicted of aggravated felonies and individuals determined to pose national security threats. If you fall into one of these categories, your due process rights are severely limited. You cannot apply for most forms of relief from deportation. You cannot appeal to federal court in most situations. The decision can be made and executed very quickly. This underscores how critical it is to avoid any criminal involvement whatsoever and to be completely truthful in all dealings with immigration authorities. Now let's talk about implementation timeline because this matters for your planning. The Continuous Status Review System officially launches on January 1, 2026. However, it won't affect everyone immediately. USCIS will implement the system in phases based on when individuals first received their green cards. The current plan is to start with the most recent green card holders and work backward. If you received your green card in 2023, 2024, or 2025, you'll likely be in the first wave of CSR requirements, possibly as early as late 2026 or early 2027. If you received your green card before 2020, you might not have your first CSR until 2027 or 2028. USCIS will provide at least 90 days notice before your first review is due. Here's what you need to do right now to prepare. First, start documenting everything today. Don't wait until your CSR notice arrives. If you volunteer at your child's school, at your religious organization, at a local food bank, or anywhere else, get documentation. Ask for letters confirming your volunteer hours. Keep those letters in a safe place. Create a dedicated file for your immigration documentation. Include copies of your tax returns, W-2 forms, employment letters, lease agreements or mortgage documents, utility bills showing your address, and records of all international travel. This file will become your CSR evidence package when the time comes. Second, get your tax situation in order immediately. If you haven't been filing tax returns, work with a tax professional right away. The IRS Voluntary Disclosure Program allows people who haven't been filing to come into compliance without facing the harshest penalties. It's far better to fix this problem proactively than to have it discovered during your CSR. Even if you don't owe any taxes, even if you're living abroad, even if you had no income, file the returns. Having an IRS transcript showing you filed is what matters for immigration purposes. Third, keep meticulous travel records starting now. Every time you leave the United States and return, document it. Create a spreadsheet with departure dates, return dates, destinations, and purpose of travel. Save your boarding passes, your passport stamps, your hotel confirmations. If immigration officials ever question your continuous residence, you'll have detailed proof of your travel patterns. If you know you'll need to travel extensively in the coming years for work or family reasons, consult with an immigration attorney about whether a re-entry permit might be appropriate for your situation. Fourth, update your address with USCIS immediately if you move. File Form AR-11 online within 10 days of changing your address. This is free, it takes 5 minutes, and it ensures you'll receive all important notices from USCIS. Missing a CSR deadline or a biometrics appointment because you didn't get the notice could cost you your green card. Fifth, avoid any involvement with the criminal justice system. This should be obvious, but it bears repeating. Even minor offenses can create immigration problems under the new system. Don't drive under the influence. Don't get into physical altercations. Don't shoplift. Don't commit any kind of fraud. Any arrest will be immediately reported to immigration authorities and will be part of your file during your CSR review. Sixth, if you're eligible for citizenship, seriously consider applying. Once you become a U.S. citizen, none of these CSR requirements apply to you anymore. You can't be deported except in extremely rare cases involving fraud in obtaining citizenship. You can travel freely without worrying about continuous residence requirements. If you've been a permanent resident for 5 years, or 3 years if you're married to a U.S. citizen, and you meet the other requirements, applying for naturalization might be the best way to protect your future. Yes, the naturalization process has its own challenges and requirements, but citizenship provides a level of security that permanent residence simply doesn't offer anymore. Let me address some questions I know many of you are asking. Can these regulations be challenged in court? Yes, and there will almost certainly be lawsuits filed by immigration advocacy organizations arguing that some of these requirements are overly burdensome or unconstitutional. However, litigation takes years. Even if lawsuits are successful, they might only block certain provisions while leaving others in effect. You cannot count on courts to save you from these requirements. You need to prepare to comply with them as written. Are there exceptions for elderly people or people with disabilities? The law includes provisions for hardship waivers and reasonable accommodations, but the details are still being finalized in the implementing regulations. If you have a disability that makes the Civic integration requirement impossible to meet, or if you're elderly and cannot travel to a biometrics appointment, you may be able to request a waiver or accommodation. But you'll need medical documentation, you'll need to make the request in writing, and you'll need to follow the proper procedures. Having a valid reason for not meeting a requirement isn't enough. You have to formally request the accommodation and provide supporting evidence. What if I already failed to meet one of these requirements? If you haven't been filing tax returns, if you've been spending too much time outside the United States, if you have minor criminal issues in your background, Now is the time to address those problems. Consult with an immigration attorney about your specific situation. In many cases, there are ways to come into compliance, to fix past mistakes, or to prepare evidence that will help you during your CSR review. The worst thing you can do is ignore the problem and hope it doesn't come up. The political context here is important. These regulations passed with bipartisan support, which is extremely rare in today's immigration policy environment. Both Democrats and Republicans voted for this reform. Democrats supported it because of the civic integration components, arguing that it will help permanent residents feel more connected to their communities and better prepared for citizenship. Republicans supported it because of the enforcement and verification components, arguing that it will ensure green card holders are meeting their obligations and that fraud will be easier to detect. This broad political support means the regulations are unlikely to be repealed, even if there's a change in political control in future elections. However, immigrant advocacy organizations are deeply concerned. They argue that these requirements place unfair burdens on low-income immigrants, on people with disabilities, on elderly residents, and on anyone whose work or family situation makes compliance difficult. They worry that the civic integration requirement in particular will be used to deny status to people who are otherwise fully compliant with immigration law, but who can't find 40 hours to volunteer because they're working multiple jobs to support their families. There's also concern about disparate impact, that these rules will disproportionately affect certain immigrant communities. Looking ahead, this is likely just the beginning of more changes to come. Some members of Congress are already discussing additional reforms, including making green cards conditional for the first 5 years, with renewal dependent on meeting strict criteria, increasing fees for green card applications and renewals substantially, limiting the categories of crimes for which relief or waivers are available, and creating English language requirements for maintaining permanent residence. The immigration system is evolving rapidly, and green card holders need to stay informed and engaged. In conclusion, the era of the green card as a set-it-and-forget-it status is over. The new regulations transform permanent residence into an active status that requires ongoing compliance, regular documentation, and periodic verification. For green card holders who are already following the rules, who are filing their taxes, who are maintaining their residence in the United States, and who are willing to meet the new civic integration requirements, these changes are manageable. But for anyone who has been cutting corners, who hasn't been fully compliant, or who has circumstances that make these requirements difficult to meet, the new system poses serious risks. The stakes are incredibly high. This is your life, your family, your future in the United States. Don't treat these changes as something you can worry about later. Start preparing now. Get your documentation in order. Fix any compliance issues you have. Stay informed about when your CSR period will begin. And if you have any doubts about your situation, consult with a qualified immigration attorney who can review your specific circumstances and help you develop a strategy. Thank you for watching Dream Visa Updates. I hope this comprehensive breakdown has given you a clear understanding of the new 2026 Green Card regulations and what you need to do to protect your status. If you found this information valuable, please subscribe to our channel and hit the notification bell so you never miss critical immigration updates. Immigration law is changing faster than ever, and we're committed to keeping you informed every step of the way. Share this video with every green card holder you know. This information could literally save someone's immigration status. Leave a comment below with your questions, your concerns, or your thoughts about these new regulations. I personally read every comment and use your feedback to create future content that addresses the issues that matter most to you. Remember, at Dream Visa Updates, we're here to empower you with the knowledge and the tools you need to successfully navigate the U.S. immigration system. These new regulations are challenging, but with the right information and preparation, you can meet the requirements and protect everything you've worked so hard to build in America. Until next time, stay informed, stay compliant, and protect your status. This is John signing off.